Welcome to From Engagement to Enforcement, Managing Fee Disputes and Non-Payment for Attorneys. I'm Belinda McCauley, CEO of the Beverly Hills Bar Association, and I'm delighted to be here today to introduce our speaker, Aleksandra Hilvert. Aleksandra is a 15-year entertainment attorney who worked at Lowe & Associates and Johnson & Johnson before founding Vault Legal, a Beverly Hills-based litigation firm that specializes in breach of contract on contingency. Vault Legal represents law firms, CPAs, production companies, talent agencies, content creators, and more, all on a contingency basis. Aleksandra's been recognized as a super lawyer since 2019, including designation as a top 100 rising star and top 50 female rising star. She is a member of the California Society of Entertainment Lawyers and our very own BHBA. And Aleksandra, we look forward to learning from you today. Let's get started.
Wonderful. Thank you, Belinda. Can you hear me okay?
We can.
All right, wonderful. Thank you to the BHBA and thank you, Belinda, for that wonderful introduction. I'm excited to be here today. Thank you to all the attendees. And with that, I'm going to share my screen and let's get moving. All right. Here we go. We are here today to discuss from engagement to enforcement, managing fee disputes and non-payment for attorneys. As Belinda mentioned, I'm Aleksandra Hilvert. I am the founder of Vault Legal. After being an entertainment attorney for 15 years, I specialize in breach of contract on a contingency. So in today's session, the goal is to give all the attendees the tools that they need to navigate fee disputes when they arise, but also, and more importantly, to give attendees the tools they need to prevent fee disputes from arising. We're going to go through best practices for avoiding fee disputes, including key terms and retainer agreements, setting client expectations, then protecting your right to payment, recognizing when things are starting to get a little dicey and when you should maybe consider withdrawing, and finally navigating taking legal action when fees go unpaid and weighing those ethical risks. We'll also talk about the MFA program, including the one that the Beverly Hills Bar Association offers. All right, so first let's go through the statistics. Now, you might be surprised to learn that no other industry lends itself to late or missed payments more than the legal industry. Why is that? Well, that is because lawyers essentially extend unsecured credit after a initial retainer is depleted. Once you get that retainer and it's paid out into legal fees, you are essentially working for free in an unsecured manner. That is a very precarious position to be in when you're operating a business. Now, small firms take the hardest hit in this situation. And why is that? Well, small firms typically represent individuals, small businesses, startups, and those businesses and entities, individuals don't necessarily have the ability for deep pockets, unlimited funding, and they might depend on financing from law firms and lawyers, as opposed to Fortune 500 companies and insurance agencies that are typically clients associated with bigger firms. So let's take a little closer look at the statistics. An industry survey done by Clio found that 14% of billed legal dollars go uncollected. 14%. Now, if you think about that, that's taking another tax, a 14% tax on dollars that you earn. And when you're working in California, paying taxes already, that's a huge additional tax on your business income. When you factor in overhead such as employees, malpractice coverage, and marketing, that extra 14% can cause a significant ripple effect on your business and being able to cover your overhead. Another statistic that I found very interesting is that 38% of law firms report at least 50% of clients pay their invoices late. And that's probably why you all are here today. So let's talk about the why and the psychological forces driving that. So I did some research and I found that there are 6 main categories as to why clients pay late. Understanding these different parameters and psychological forces will help you avoid payment disputes down the road. The first 3, the good news is that those are largely within your or the attorney's control. Let's talk about the first one, vague or flexible billing practices. If you are vague and flexible with when you send out invoices and when invoices come due, you're going to be met with inconsistent payments. Why would you expect somebody to pay you on a set schedule if your invoices are not going on a set schedule. So that's completely within your control as the attorney. The next one is weak client screening or no due diligence. So when you're taking on an intake, considering taking on representation of a client, the first thing I always recommend attorneys do is search the client and make sure that they are able to pay their bills. They're not repeat offenders, so to speak. And how do you do that? Well, most people know by now that you can search on the LA Superior Court website any individual or business for a whopping $1. $1. And you will have a lot of information about whether that person or that entity has been sued by creditors, credit card companies, landlords, other businesses, and even law firms. So if you have a situation where, you spend the dollar, you do the search, oh, wow, this individual has been sued multiple times, there's judgments and liens in their name. Well, I would recommend either you do not take them as a client, do not accept representing them, or you look to number 3, which is an evergreen retainer in connection with that representation. Evergreen retainers, of course, mean that when a large retainer amount has been depleted by legal fees, it is replenished such that you never get into a situation where you're extending unsecured credit, as I discussed at the very beginning, because that can put you in a precarious situation with your client. Now, let's talk about the next 3, which are a little less out of our control, but I will give you some tools today that will help you make them more easier for you to navigate these other 3 reasons why clients don't pay or pay late. First one, the intangible nature of work. Obviously, what we're providing is a service. It's not a tangible good. And so clients sometimes don't feel that outcome. They don't see the outcome. They get lost in the abstract, excessive drafting, calls, strategy meetings. And so there are some tools, and we'll talk about later, how to make your work and your practice feel more tangible to clients. The next one is that clients, when they come to attorneys, are oftentimes in a weak or very vulnerable state. Whether it's family law, personal injury, a business dispute, nobody is excited at the prospect of hiring an attorney and paying an attorney on an hourly basis. It's very rare, I would say, that clients are excited to, search a lawyer and have to sue somebody or defend themselves in a lawsuit. So along with that vulnerable state, they are focused again on the outcome. So you need to keep that in mind when you're asking for invoices and bills that are coming due, because you need to provide some sort of context around what that invoice represents and have that be more tangible for them. Now, the last one is that there is a perception, a stereotype, if you may, that lawyers are financially stable. There's a stereotype about lawyers and flashy cars and having, living in a life of excess, et cetera. Now, you have to dissuade clients of that, because actually the opposite is true for most attorneys, that the lawyers are very hardworking people and they have a lot of overhead, like we discussed earlier. So you have to build into the bill what it is that the client is getting. It's not just, a piece of paper with a number at the end. It's the tangible value of what that is, and that is important for the client to understand. Now, after understanding the why, let's talk about the good news. There's some good news here, and that is that the legislature and the judicial body of California have provided us with some really great resources. And we're going to talk about all 3 of these categories today. You will have the 3 components from courts and the legislature to understand how to protect yourself when you're in a situation where clients don't pay or pay late. The first one, withdrawal, we'll talk about, but courts do routinely permit withdrawal for non-payment with proper notice. The next one is malpractice protections, which most attorneys know. It's a 1-year statute in California, which is a very short statute. So if you have an invoice that's, I like to recommend to my clients, if they're going to be suing a client, to wait the 1-year statute for malpractice to run, so that there's less chance, not no chance, but less chance that they will be countersued for malpractice in those situations. And the last one is the MFA program, which is a great program that the state bar runs. Okay, now let's talk about the most important part of your legal representation, is the fee agreement. Most attorneys know that fee agreements have to be in writing if you were going to pay anything over $1,000 in connection with a representation. And most attorneys also know that all retainer agreements have to comply with the model rules and the rules of business and professions codes. However, what most attorneys don't know is that the state bar actually has a tremendous resource available for free for all attorneys, and that is template retainer agreements for hourly litigation matters, hourly non-litigation matters or transactional matters, and finally for contingency representation. And I will tell you that the contingency representation of retainer agreements are very detailed. And in California, there's many, many parameters that attorneys must include if you have a practice running on a contingency basis. And the state bar templates have everything provided in those template agreements. And we'll look at a sample in a minute, but the templates that I'm going to show you that are on the State Bar website, and I'll show you one in a second, have the requirements of the scope of services, a disclaimer about malpractice, which is required. In California, you do not have to have malpractice coverage, but you have to tell your client in writing, and they have to consent to knowing that you do not have malpractice or errors and omissions coverage if you do not. And the retainer agreement also has to have invoicing parameters, such as how often are you sending out invoices? When do they come due? If there's no deadline, there's not going to be a breach deadline for you to move to withdraw. So it starts and ends with the retainer agreement because you have to have those dates and deadlines in there, and not just have them in there, but then you have to follow those. You can't say invoices are submitted or generated every 30 days and then not send an invoice for 6 months. You're breaching your own retainer agreement, essentially. However, the templates online on the State Bar website do not have 3 really important categories that I'm going to go over that I think every attorney should include in their retainer agreements. The first one is adding an arbitration clause. I know most people think arbitration is expensive. You have to pay for the arbitrator's time. However, it's private, it's confidential, and it's much faster than a typical lawsuit. Furthermore, if you end up suing your client in state court for unpaid fees, you are subjecting yourself to discovery of your billing practices. All of that can be out in the open, and a lot of that is proprietary. You don't necessarily want that to be publicly available. What if there's a dispute about your invoice and there's a ruling that is unreasonable? So I recommend to all my clients to have arbitration clauses in their retainer agreements. The next one is having attorney's fees provision. Sounds pretty obvious. Some people just don't include them in their retainer agreements, but having a prevailing party attorney's fees clause is crucial to protecting your business and adding teeth to your retainer agreement should an invoice come past due. And the last one that I'm going to discuss that should be added is interest, having an interest clause. Now, interest, it's obvious. We all know what interest is. However, you might not know that in California, not only do you have to have an interest clause consented to by your client in writing in a signed retainer agreement, but it also has to be listed on the invoice itself as a separate line item, that interest is being charged at this rate, and this is the amount of interest. Of course, in California, it's subject to usury laws, et cetera. It cannot exceed more than 10% per year. However, you can start charging interest on a monthly basis when the invoice comes due. You do not have to wait the full year. So you can start charging 1 or 1.5% per month compounded, as long as A, it's in your retainer agreement, and B, it's also clearly and explicitly listed on your invoice. Okay, so here's the template, and this is also available in your materials. I've provided all of the template State Bar fee agreements in the materials. This is just the first page of one. This is for a hourly litigation matter, and again, even if you have a great retainer agreement, you've met all the requirements from the State Bar, I do to take a look. They do update these quite regularly. This one was last modified in 2019. However, practice, make a habit of every year or so checking out the templates on the State website, make sure you're not missing. Okay, so let's talk briefly about interest rates. What's interesting is that in the 1960s and 70s, lawyers were precluded by the State Bar from charging interest. the state bar viewed it as a bargaining weapon, and they precluded attorneys from charging interest, and they also precluded attorneys from taking credit card payments. However, that's all changed, and in State Bar Form Opinion number 1980-53, interest can be charged if the client consents in writing, which we just went over, and it is reasonable. So again, going back to, it can't be higher than the state constitution, which is at 10%. And let's see. So, oh, and finally, I mentioned this earlier as well. It has to be clearly depicted on your invoice. And here's an example of that language. Accounts not paid in 30 days are subject to a 1.5 monthly interest charge. So you need to have all three of those if you are going to be charging your client's interest on late invoices that are past due. All right, so take a sip of water, 1 second. Okay. Now, let's say you've got a great retainer, you know it complies with everything the state bar requires, all the bells and whistles. You have great detailed invoices that provide a special call out for interest. How do you increase your chances of getting paid? There's a couple of little practical things. First is charging or accepting credit cards. I understand that credit card companies do take a percentage, about 3%, but that's really small when you compare to the 14% of legal bills that go unpaid. So that we talked about earlier in the statistics. So you're really increasing your chances of getting paid if you accept credit cards. A lot of people, again, if you're a small firm, you have clients that typically, might live paycheck to paycheck. They don't have deep pockets. They don't have huge savings accounts. So they're going to appreciate an attorney that's flexible and will accept credit cards, and choose an attorney that does accept credit cards over one that doesn't and requires all payments to be cash or ACH. Well, not cash, but ACH or wire. The next one is early payment discounts. Now, this is interesting. The state bar used to preclude early payment discounts back in the 60s and 70s. That's all gone away now. And it's green light go. I've seen this work in practice, and it's great. If you send out invoices, you can send in the cover email, don't forget our firm offers 10% off if you pay early. And that, coupled with the fact that you could charge interest at 1% per month if it's late, can be a sizable amount of money or amount of savings to incentivize your client to pay. Now, the next one is consistent billing, which we talked about earlier. And that is very crucial to make sure that your business is flowing and operating well. My firm uses a software called MyCase, and this is not an advertisement. I'm not sponsored by MyCase or anything, but what's great is that all of my timekeeping is in MyCase. And not only that, but invoices are generated automatically with the interest language. And finally, they're sent automatically to all the clients at once when I hit, yes, these are approved. And lastly, MyCase will accept credit card payments from the client. So everything's automated. And there is an overhead for that service, but it's worth its weight in gold to make sure you're consistently billing and that your invoices have the right parameters and you're also accepting credit cards. Now, finally, the human touch element, going back to the psychological factors that go into clients maybe paying late or not paying at all. If you some sort of update, some sort of milestone benchmark in your invoice, you're much more likely to get paid. It's a good habit to get into, to maybe before bills go out, have a call with your client, tell them what's happening in the case, tell them what's coming next. What did you accomplish for them? And give them actual, concrete, tangible, again, remember that word, tangible milestones that they can process, so that when the invoice comes in, they say, okay, well, I know what I've gotten and there's value there, so now I'm going to pay this bill. Okay, so the other thing that I like to mention to clients is to make sure that your clients, your legal law firm clients, feel like they're part of the process. Instead of sending a client a final redlined agreement or an opposition that's been drafted and filed, have them be part of that process. Send them a draft of it. Send them a red line of it. Now they're seeing the work. They're seeing kind of how the sausage is made. And that makes it more tangible for them to understand what it is that you're doing. If they see the final product in a bill, they're not going to be as open to just cutting you a check for $10,000. But once they see how much time and energy and phone calls you had with them, it makes it much more tangible for them. Okay, and a pro tip, bundle as much of these as you can. If you accept, again, early payment discounts, no interest, credit cards, you're much more likely to get paid in the long run. So let's say you have a great retainer agreement, you've got, good billing practices, and your client still doesn't pay. What do you do? Well, going back to what we talked about earlier, now you're in a situation where you're extending unsecured credit to an individual. And that can be quickly taken advantage of. And I've seen this happen in practice. So the first thing I tell clients is you need to know when a bill is due, and you need to follow up. That basically is sending a warning letter, a notice. You're in breach. You didn't pay. What's going on? Did you get the bill? How can I help? Do you have questions about the bill? All of those are important in terms of your timeline before you withdraw. After you send the warning letter, if the client does not make arrangements to pay, you are encouraged to withdraw. And I will tell you that the sooner you do so, the better. You need to trust your instincts on this. If you are in a situation where the case is in litigation, we'll talk about this, but you're going to have to get the court's permission to withdraw. And that if you wait too long and there's prejudice to the client, or they're in a state of peril, it will be much more difficult, or it might be denied. And you might end up having to work for that client basically for free, which can be even more taxing on a business or on a law firm. So I recommend trusting your instincts and withdraw sooner than later. Hand in hand with the withdrawal, whether it's court approved or voluntary, you must send a disengagement letter. And we'll go over that in a minute, but this is the date that triggers the statute of limitations for malpractice. And it's very important to protect yourself. Now, finally, the last step is to send the client's notice of rights to arbitration. This is the document that you send before you are able to sue your client for unpaid fees. And it's very important. If you do not send this document, the case can be dismissed, and likely will be dismissed. And I have a template of that form in the materials provided for you, and we'll also look at one as well. Okay, so here is the client's notice of rights to fee arbitration. In California, before you can sue your clients for unpaid fees, you must send this notice out and give them 30 days to select or elect fee arbitration. This is all part of the state bar's program. And the state bar started this because before the MFA program, or the fee arb program, attorneys were suing their clients ad hoc in state court. And the courts were just up to their eyeballs in fee disputes, unpaid fees. So they started this program to kind of streamline fee disputes between attorneys and clients, because they are so numerous. Again, going back to the fact that our industry, unfortunately, is more ripe to this type of fee disputes than most others. So this document, it's very simple. Again, it's in the materials. You fill out the information, the client's name, what the matter was you represented them on, how much is due, and then you tell them there's a program that's available to handle the fee arbitration should they choose to elect it. The Beverly Hills Bar Association has a program. The LA County Bar has a program as well. And you send that notice to them. I like to serve people with it, individuals with it, because then you keep that proof of service as well. So you have proof of when it went out. If they have email and they check their email, it doesn't get bounced back, that's fine to do as well. You send that out, then you have to wait 30 days. You calendar the 30 days. After the 30 days, if that client of yours, of your law firm, has not initiated fee arbitration through one of these programs, then you are free to go ahead and proceed with legal action against them, whether it's arbitration, whether it's going to court, suing them in state court. But this form is the trigger for you to be able to proceed in court. Okay, let's now talk about when to withdraw. Timing is everything. Under Model Rule 1.16b5, withdrawal is permissible if the client breaches a material term of the agreement and the lawyer gives a reasonable warning. Again, going back to, you have to say, hey, this came due. Why didn't you pay it? What's going on? Do you need another copy? Do you want to talk about it? But again, you cannot leave your client in a state of peril. The key considerations are to not move for withdrawal if you're in an active litigation matter, if there is law in motion pending, motion's been filed that you need to oppose, if there is significant discovery that is outstanding, it will be less likely that the judge is going to grant your motion to withdraw in those situations because of the obvious. The client's going to miss a deadline. The client is going to miss, waive their objections to discovery responses, what have you. So if you want to move to withdrawal when things are really heating up in litigation, you have to continue those dates. You have to get a stipulation from the opposing counsel and say, hey, we're going to be filing a motion to withdraw. Will you agree to table all these dates and deadlines, oppositions, response dates for 30 days after new counsel has been brought into the case? If you don't do that, you're going to be leaving your client in a state of peril, and the judge will say no. The judge, if you are in an active litigation, the judge has to consent to you withdrawing. So again, going back to once a term has been breached and your gut is saying this client is going to stiff me, I can't work for free, that's when you should withdraw. Sooner the better. I've had situations where a client opposed. So I represented a law firm. We moved to withdraw. The client opposed the application to withdraw, saying that he could not afford new legal counsel. Well, in that situation, I mean, the judges get it. No judge is going to say, okay, well, you keep, working with this law firm and not paying them, because judges want to help attorneys. They're not here to hurt us. They want to help us. As long as we're doing our jobs and we're treating our clients fairly and not prejudicing them, the judges will be on your side and will help you withdraw from a matter. However, I will say this too. You have to be very careful in your declaration in connection with your motion to withdraw, because you can't reveal attorney-client privilege information. That could be private facts about the client. For example, you can't say, oh, this client is going through a divorce and they lost their business and now they have cancer and they can't pay their bills. If that is not publicly available, you cannot say that. That is a violation of attorney-client privilege. So what do? You have to finesse it. Judges are smart. They understand. You say, Your Honor, they breached a material provision of the retainer agreement. We've given them a warning. They breached it again. It's now incurable. There's no recourse. We're at an impasse. Judges will understand, but you cannot put private information into those public pleadings, because that can come back to haunt you and be a state bar violation. Okay, so now let's talk about disengagement and non-engagement letters. We touched on this earlier. You withdraw, or at the same time, if it's not in litigation, you can send a notice of withdrawal and a disengagement letter. That could be one and the same. If you are in litigation, you have to file your motion to withdraw. After it's granted, you may then send your client a disengagement letter. This is a clear date, an effective date of your non-representation of the client. The date is key for statute of limitations purposes, for malpractice, and there are other requirements as well. You must, in this letter, state how long the file will be maintained and clarify to the client about return of materials. You must also advise the client of pending deadlines and dates that are coming up in litigation, or if it's in pre-litigation, statutes of limitations if it hasn't been filed yet. And finally, you must also advise your client if there are fees that you owe them back that should be refunded to them. Now, if you're in a situation where they haven't paid you and that's why you're withdrawing, that's not going to be the case. So in that case, you would say, oh, and also there's the issue of your bill. You owe me X thousand dollars. Call me to discuss. Let's try to work this out. But as of today, we are no longer representing you on this matter. Now, another thing, I'm actually surprised at how few attorneys send out non-engagement letters, but the State Bar does discuss this at length, and it is very important in your practice. And if you have an intake and you should make a habit of sending non-engagement letters. It can be very short, can be via email, it doesn't have to be a formal letterhead letter saying this, we are not going to be engaged by you to represent you in this matter. These letters are also important because I've had a situation where I had an intake with a client and I thought it was pretty clear that I didn't have the bandwidth to take on this matter. Lo and behold, a week later, the client starts forwarding me correspondence from opposing counsel saying, how do I respond to this? I need your help. Whoa, that's where this is what it can snowball. All of a sudden, I have to say, I'm not even retained to look at this. I can't engage in this. I can't respond to you. I'm not your attorney. So it is important to do that because sometimes you get in those situations with clients that are a little extra zealous. The other thing that I like to add in these non-engagement letters is that the decision to not represent a client is just a business decision. It doesn't have any weight as to the merits of the case, and that the client should look to other counsel. Maybe you want to refer them to somebody else. That's always a great look. Potential clients love that. If you have a referral for them, that's even better. Okay, now let's talk about not the elephant in the room, but the key component of today's program, which is the mandatory fee arbitration program. I'm here to tell you that the MFA program is a great resource. I know a lot of attorneys think, oh, I hope my client doesn't elect fee arbitration. I don't want to deal with that. But actually, it's if you do it once, you understand that it's actually a program to help attorneys because it really streamlines things. If a client doesn't elect fee arbitration, then you are going to be stuck suing them. They most likely will countersue you for negligence, what have you, and then you're potentially in litigation for some time unless it's resolved quickly. The MFA program is hyper-focused on the fee dispute itself and cannot look at malpractice, cannot look at negligence of an attorney. Some arbitrators can look to allegations of negligence and offsetting the fee bill that's due. But when it comes to the MFA, it's a highly specialized, highly focused arbitration that's just for billing disputes. And what's the process like? Well, it's an arbitrator or a panel, depending on how much is at issue, and they just review the fees that are paid or owed and hear from both sides of the parties. It's pretty informal, I will say. It's not a very formal process. There's no discovery. However, you're going back to the retainer agreement and your invoices. The fee arb is won or lost before you even start the arbitration based on your evidence. It's like the old expression, a case is won or lost before you get to the courthouse steps based on your evidence. So here, your evidence is going to be the retainer agreement, your invoices. How often did you send your invoices? Was it, every 30 days? Per the agreement? Did you stick to your own agreement, or were you just ad hoc sending them as you needed to make money? So be careful with that because that's what arbitrators like to see in fee arbs is that as an attorney you're hyper organized, you're diligent in your invoicing and in collecting on your invoices. So how are the fees paid for the fee arbitration? I know that comes up from time to time. It's actually a percentage. It's a 5% of the fees in dispute is what the moving party would pay. So if you send your client the notice of rights to arbitration and they say, yes, I want fee arbitration. I don't want you to sue me in state court. Let's do this. The client would file for fee arbitration and they would pay the 5% up to $1,000. That's the most that a client would have to pay for fee arbitration. So another thing I want to mention is that there's a 30-day rule with the MFA program such that if after an arbitration, there's a ruling that comes down with the fee arbitration, either party has 30 days to appeal it. It's a non-binding decision, but if it's not appealed, then it is considered binding after the 30 days. If somebody does appeal it, it's a trial de novo in state court. But if it's not appealed, then it becomes binding. It becomes a binding order of the arbitrator. All right, so I know that was a lot of information. This is an important part I want to discuss. The state bar a few months ago released ethics opinions, which are really exceptional. And they are such a great resource if you have questions about fees, how much, when to collect, interest, contingency fees, liens, you name it. There is so such a wealth of information in these ethics opinions. They're all hypotheticals, but they give real world kind of examples. Company XYZ hires attorney J, da da da. And these are also in the materials. Now, if you look over here, there's a section here for fees on, so I think it starts on page 15. So you can, that's hyperlinked on the State Bar website. If you go to that, you come up, you get this screen, which is another database of hyperlinked opinions. And each of these is organized by topic. Now, these are great. They range from everything from contingency fee liens to referral fees. And they're a great place to go if you have a fee dispute because you can reference these with your clients and say, hey, I know we have a dispute about this. Well, there's an ethics opinion that holds that I'm right and here's why. Or if you might realize that you're wrong and you've been overcharging your client, or there's a reason to discount your bill. But these are great, and most attorneys don't know that these ethics opinions are available online because, again, this just landed a few months ago. So with that, the final thing I want to discuss is suing your client. You're in a position where you've done everything. You sent the client's notice of rights to arbitrate. They did not elect to go to the MFA program. You're still sitting with a big bill, and you know the client has the resources to pay. They're just taking advantage of you. Well, then there are times when I say, well, you need to sue them or take them to arbitration. The considerations are that it's public record if it's not in arbitration. And so your billing practices, invoices could be part of the public record. And usually if you sue a client for fees, they will countersue you for malpractice. If you wait out the 1-year statute of limitations, which I recommend everybody does before suing their clients for unpaid fees, you still might get a countersuit for negligence for offset. However, if you have an attorney representing you, they could probably get that, dismissed on a demur for statute of limitations having lapsed. So I think the biggest thing is that when I represent clients who are owed, and I represent a lot of law firms who are owed money from clients, my biggest recommendation to them, the first thing I say is call your client and have a conversation, because a lot of times when I get cases, the clients just want to be heard. And I get them on the phone and I say, hey, what happened here? Tell me in your own words. And sometimes they just want to vent and say, gosh, I was really happy at the beginning, but then I didn't get the result I wanted. And here's what happened, da, 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 da. And you just listen to them. And sometimes just listening to them, they then realize, okay, maybe I didn't get the results I wanted, but I still got something, or this person still deserves to be paid because they have families and they have overhead and they have staff and et cetera. So it's just the human component, kind of going back to that psychological human component of being an attorney. A lot of times we're just sitting there on our computers and buried in paper and deadlines, but just picking up the phone and calling, that to me is always the first step in resolving these disputes and avoiding the headache of public action and your billing practices being under scrutiny. So with that, I've concluded, and I would love to open it up for questions if there are any. Thank you for everyone's time.
Yeah, we do have some questions. So we have a question from Barbara. It says, would you please repeat where you suggested the $1 search of prospective clients?
Sure, I'm happy to do that, Barbara. So if you go on the LA Superior Court website, you can under online services, you can search for parties. There's a subset where you can search for parties. And in there, you have to create an account. It's a LA account, LA court account, and you have to enter in your credit card information. And from there, you can search any person and any entity, and it'll search the entire LA County database, court database for judgments, liens, cases they've filed, cases that have been filed against them. So it's under online services. Also, Orange County courts have the same. If you have a client that lives in Newport Beach, go into the Orange County database and see, it's worth $1 to spend now. It's the cost of doing business rather than putting yourself in a situation where you're representing somebody who's a, serial defaulter, let's say, and has possibly gotten sued by many other entities or law firms in the past. And also, one other thing, if you are starting to represent somebody halfway through a litigation and they were fired by their last firm, well, there's a red flag. Well, why were you fired? Oh gosh, I don't know. We just didn't get along. Well, it's probably, maybe call up that attorney and just say, hey, like, is there anything I should know about the potential client without waiving privilege? Because maybe they'll say, yeah, they stiffed me. They paid their initial retainer and didn't pay a penny after that. So things like that are important considerations as well.
Okay, we have another question from Jack. Can a fee agreement be click wrapped and not a DocuSign?
Click wrap. I'm not sure I know what that means. Is that like a signed?
Not really sure. So
I'm not
we can
sure.
move to the next question. From Jack again. 1.5% per month interest is 18%. That's okay? Question mark.
What, so under California usury laws, the maximum you can charge is 10% per year. I believe that's still the case. So if it's 1.25, maybe I misspoke, but you're safer to charge, a little under 1% then if you're talking about, 12 months.
Perfect. And another question, can an attorney trigger the mandatory arbitration, or does it only the client have the right to trigger the process?
That's a good question. Only the client can initiate the process. If you have a client that wants to initiate it but doesn't matter. After 30 days that is waived. They have to consent to the process. So if you say to them, "Hey, I think we should go to FIARB, I'll file it and I'll pay the 5%, but you have to consent and join in," that would work, but they have to consent to it or else you're going to have to just file in court or in arbitration.
Perfect. Another question is, have you won an attachment order pre-MFA?
No, no, a right to attach. I have not in my experience, but those can be valuable and useful. It's a lot of paperwork, but they can certainly be helpful. I would not recommend those unless you know that the client is solvent and you can collect on that writ.
Perfect. And he added up, CLIPRAP means they reply by email, quotations agreed.
Now, by state bar, and here's another caveat in the state bar. You need to, if you send your client a PDF of a retainer agreement unsigned by you and they electronically sign it, you then need to countersign to have it fully executed and send it back to them. If you don't counter execute and send them the fully executed, it could be void. So in my practice, what I like to do is I get the PDF, I sign it first, and I send it to them. Then once they sign it, now they've got it fully executed. I don't have to do that last step because it can be voided if it's not returned to them fully signed. So it's just an annoying little thing that you have to make sure you do because it's an important step.
Perfect. And that was the last question.
Okay, great. Well, thank you. And if any other questions come up, my email information is in the slides, and I hope this has been helpful for you all. And thank you again to the BHBA.
Thank you, and you guys have a good one.
Thank you.
Bye-bye.